All rise.
Hearing in the appeal SB Children.
Yes, Mr. Hayden.
I appear on behalf of the appellant mother in this case, Mr. Leonard Friend's case. The local authority is represented by Leonard Friend, Miss Greycock, who sits immediately to my left, and the children who are outside their children's garden are represented by Mr. Friend's Jones and Leonard Friend's Jones. My lords, there are two late documents. May we just confirm the matter of housekeeping that happened?
I'm not sure we've received them. I'm not sure we've received them. Tell us what they are, and we can.
We made inquiries this morning in the code that the laws have. One is the transcript of the application made by counsel before Judge Kushner on the 4th of June.
No, it's not in the appendix. I mean, what I have are the appendices, but no more.
No, it was requested by the local authority and arrived late in the day. It has been communicated electronically, and I understand inquiries were made this morning, and it was confirmed that it was here.
Well, do you need to refer to it at the very start? We can get them.
What is the other document? That's it. Yes. So that our registrar can go and find them both.
The other document is Re T, a decision of the Court of Appeal, dated the 20th of November, which is important.
Mr. Hayden, in this court, it helps to speak very loudly, and it also helps to put your microphone on, although that doesn't help this end, so you still have to speak very loudly.
We've got Re-T. Yes. We've got Re-T, if that's any comfort to you, which has come in as a supplementary authority. So that much we have, but I don't believe we have the transcript.
Lords, this is an appeal brought on behalf of the mother, 23-year-old mother, of two children, Jay, who is now 2.5 years of age, and W, who is 16 months of age. It is an alarming and highly dispiriting feature of the case that Jay has now been in foster care since he was 4 weeks of age, and that his brother Warren, who happily is placed with him, W I should say, has been in foster care all his life. The agreed statement of facts document plots the litigation history of this case. I do not propose to take the court through it set out in chronological format, but it plainly reveals a process which has been buffeted by listing difficulties, shortage of available court time, and sometimes too by extraneous events, such as, for example, the mother's ill health following the birth of W. Throughout this process, if we may say so, and we do not anticipate that this is in any way controversial, this young mother's commitment to the litigation process has been unflinching. She has cooperated with assessments, and as my lords will have seen, reassessments. Her attendance of contact has been unimpeachable, and the quality of that contact has impressed every professional who has had occasion to observe it. My lords, there is agreement amongst each of the parties to this appeal that this case highlights real difficulties for both judges and advocates as to the correct approach to what we will call, if we may convenience, the uncertain perpetrator cases at the fact-finding hearing in public and private law disputes. That said, Lords, our primary position remains as it has done throughout. That first articulated by Manfred's case before the first instance judge, that on a proper construction of her fact-finding judgment, the primary judgment, handed down on the 3rd of April 2008 now, the judge had in truth exculpated this mother, and this therefore is not truly an uncertain perpetrator case.
You go on, just to be quite clear where your stance is. I mean, I understand that point that you make, but assuming it was an uncertain perpetrator case, you then ask us to go further into the addendum.
We address it, and I just set that down as our primary premise. That
yes.
We certainly must address the uncertain perpetrator.
Why, Mr. Hayden, do you put it in the way that you do? It's a way that has always worried me in these cases. Your primary case, as I understand it, is that the judge found that father did it.
Yes.
It follows that mother didn't.
Yes.
But the focus is on whether you can identify the perpetrator.
Yes.
If you can, that's the end of the matter.
Yes.
Rather than, can you rule out with absolute certainty other people? Which is why I'm worried about talking about exculpation. Because it gives the impression that you're going to have to be convinced, even to a higher standard than the balance of probabilities, that X didn't do it.
Yes, I'm replicating some of the language that is
You
used
are.
in the authorities.
Yes.
Well,
Well, I'm not correcting you, I'm just raising a concern about this language.
the language we say is just a morass of confusion in this area. My lady is absolutely right. What we say is not that the mother was exculpated or that there was any responsibility on her team to seek her exculpation, but the judge applying the balance of probability test to the evidence before them had in fact found on that test, as the lady says, that the father was the perpetrator. My lords, the first of the issues that we identify is at page 18 of the agreed statement of facts and issues document, which is the second tab in the core volume.
Yes.
We frame the question there, is it, as the appellants contend, now settled law that the test to be applied to the identification of perpetrators is the balance of probabilities as clarified by the House of Lords in Re B. Each of the teams, each of the parties here, accepts that the answer to that question must be yes.
Yes.
I don't think there's any question.
It is nonetheless necessary to linger a little on it, because the proposition did not appear to be accepted by Lord Justice Thorpe, if we may respectfully say so in the Court of Appeal, nor was it accepted by Her Honour Judge Kushner at first instance, where she in fact appeared specifically to discount it.
Mr. Hayden, I come completely fresh to this whole field.
Yes.
I thought that there are the two stages, the threshold stage, which is all about, what is it, section 31.2, and then the welfare stage, where you start getting into the section 1.1 welfare principle. I thought, but what you've already said, it may well be that I'm completely wrong about this, that Re B was about the threshold stage.
It's about the threshold stage. What is the test to be applied to establishing whether the threshold criteria are met, and also as to the identity of the perpetrator, which is part of the threshold criteria.
Is it? I thought the threshold test was, is this an abused child? I mean, that's obviously very much shorthand, but...
No, that abuse has to be attributable to a carer. My Lord, the issue at the fact-finding hearing, as part of the issues of the threshold criteria, is the identity, if it is possible to establish it, of the perpetrator. My Lord, I'll look at that in a moment too, in a little more detail, and I hope
Could we perhaps just make, I think part of the difficulty may be that there are, of course, two issues for the court. One is the threshold are the criteria of Section 31 subsection 3 established. And then the second one is what's best for the child in the light of that. But the practice of dividing up the fact-finding from the what do we do about it can sometimes adopt a different dividing line. Because it may be that you want to find more facts than you need to find in order to cross the threshold.
yes, and the lady, I propose, if I may, to address that very issue by reference to two, one to the case of CB and JB, which carefully identifies those facts which are thought by the parties to be in issue, emphasises that they should be tightly drawn and tightly timetabled, and we see it also replicated in the practice direction for domestic violence too. It's honoured perhaps more in the breach than the observance in the litigation history of this case, but it does help to focus precisely what the fact-finding hearings should be about.
Taking up my Lord's question, you may not need to identify a perpetrator to cross the threshold, as long as you can say that it's attributable to the care that the child was receiving, not being what it would be reasonable. But on the other hand, for the purpose of finding out what's going to be best for the child in the future, identification of the perpetrator is vital.
Absolutely so.
If you can.
Quite so.
So it's a bit of both. But you need to do, in a way, when you're having all the evidence about who did what to whom,
well,
it makes sense to decide that at the first fact-finding issue.
In essence, an obligation upon the applicants at an early stage of the process to evaluate the evidence and to see what factual substratum can be established in order to go on to stage 2, to apply the welfare checklist criteria to it, to consider the evidence, to see that if it supports a finding of non-accidental injury, and if it also indicates who the likely perpetrator of that injury is. And those cases in our submission will be usually the sort of cases that are suitable for split hearings. Now, my Lords, we were saying that the answer to the first question must be yes. It is perhaps, I hope, helpful to look at what Lord Justice Thorpe said about this in his judgment of the Court of Appeal, and that is at Appendix 1, pages 14 and 15, paragraphs 14 and 15. Paragraph 14, the judge states, it seems to me that although Mr. Hayden's argument is skillfully constructed and plainly wrong, the issue that the House considered in review was where a party seeking to prove an event, usually an abusive act or injury to a child, is that to be proved on some sliding civil standard elevated proportionally to the gravity of the injury, or is it to be proved simply on the balance of probabilities? Thus, if the judge is satisfied on the balance of probabilities, the consequence is that the judge is not so satisfied, then the consequence is that the event alleged did not occur. That, of course, says the judge, and with respect, no party to this appeal would support the following characterisation. That, of course, says the judge, was a sweeping departure from the earlier authorities of the House of Lords in relation to the trial. The judge goes
I think it's also common ground that sweeping departure is not an accurate description of reason.
I thought Age had already decided that there's no such thing as an intermediate standard of proof.
No party to this appeal would seek to support Lord Justice.
Well, I wondered what he meant. I mean, it seems such an extraordinary statement, really, given the clarity of the opinions in Re B. It's very difficult to understand what was passing through his mind, unless he had something else that's there, but it doesn't really come out of the judgment.
It's always dangerous to speculate
what may have been in somebody else's mind.
It goes on and off each time you lean forward.
You could move slightly, I think, to your left, and you might avoid the button.
Yeah, I think I've positioned myself. We think what Lord Justice Thorpe had in mind there was that the clarification that the standard of proof to be applied was the balance of probabilities, nothing more, nothing less, rather than what is for convenience referred to as the heightened cogency test that appeared to be stated by Lord Nichols, was what the judge had in mind when he perceived there to be I see. Yes, I think that's what he had in mind.
Yes, so it's that little bit of Lord Nichols that is in his mind. That's why I wondered, really. I mean, the sentence needs to be fleshed out a little bit, because one can easily disparage it as being an obvious mistake. But I think
on your case, is there any departure, or is there any difference between the reasoning of Lord Nichols and the reasoning in B?
The reasoning of Lord Nichols in Re H,
In Re H,
and
yes.
Re B, it is a clarification of Lord Nichols.
And so what's the answer to my question? That's to duck the question, in my opinion.
Well, this court excised some passages which had given rise to the confusing nostrum that the more serious the allegation, the more cogent needed to be the evidence in support of it.
Yes.
It was a very familiar line of reasoning in all sorts of fields.
Yes, it was.
Yes.
In the wider civil jurisdiction.
Yeah.
Yes. So, insofar as that is the change, there is a change. But to characterise it as a sweeping departure from the earlier authorities puts it far too high, if we may say so.
Yeah.
And so, the judge goes on, Re B, he says, the House was not specifically concerned directly with the proper approach to the determination of inculpation or exculpation of two adults who were simultaneously or from time to time with the care of the child, and therefore with the opportunity to have inflicted the injury. Taking Baroness Hale's earlier point about the appropriate language to use, what the judge is really saying there is that the House in Re B had not specifically or directly addressed the test to be applied in identifying the perpetrator, putting aside phrases such as inculpation or exculpation. My Lord, in our submission, the House of Lords plainly addressed those issues, and it may be convenient just for a moment to look at where they were addressed. My Lords, may we turn to Re B, which is at tab 3 of volume 1 of the authorities. At paragraph 73. The paragraph there probably has to be set in the context of the earlier paragraphs. From paragraph 62, Baroness Hale is considering the whole issue of the standard of proof to be applied in fact-finding hearings generally, but the point that is in focus here is really that in paragraph 73, where Milady says, in the context of care proceedings, the point applies with, this point
What
applies...
is this point?
This is the inherent problem. My Lord, shall
Well,
we...
there's no logical or necessary connection between seriousness and probability. It's the point in in paragraph 72.
It is, with some illustrations of the dogs and the lion in Regent's Park. In the context of care proceedings, this point applies with particular force to the identification of the perpetrator. It may be unlikely that any person looking after a baby would take him by the wrist and swing him against the wall, causing multiple fractures and other injuries. But once the evidence is clear that that is indeed what has happened to the child, it ceases to be improbable. Someone looking after the child at the relevant time must have done it. The inherent improbability of the event has no relevance to deciding who that was. The simple balance of probabilities test should be applied. Lord, we say it couldn't be clearer than that, and it is made equally clear by Lord Hoffman at paragraph 14. And finally, the judge says, I should say something about the notion of inherent probabilities. Lord Nichols said in the passage I have already quoted, and then the hyperpotency must be set out. I wish to lay some stress upon the words I have italicized. Lord Nichols was not laying down any rule of law. There is only one rule of law, namely that the occurrence of the fact he issued must be proved to have been more probable than not. Common sense, not law, requires that in deciding this question, regard should be had to whatever extent appropriate to inherent probabilities. If a child alleges sexual abuse by a parent, it is common sense to start with the assumption that most parents do not abuse their children. But this assumption may be swiftly dispelled by other compelling evidence of the relationship between parental and child and parent and other children. It would be absurd to suggest that the tribunal must in all cases assume that serious conduct is unlikely to have occurred. In many cases, other evidence will show that it was all too likely. If, for example, it is clear that a child was assaulted by one or other of two people, it would make no sense to start one's reasoning by saying that assaulting children is a serious matter and therefore neither of them is likely to have done so. The fact is that one of them did, and the question for the tribunal is simply whether it is more probable than one rather than the other was the perpetrator.
I mean, help me on the facts. Was B actually an uncertain perpetrator case?
No, it wasn't.
That's what Lord Justice Thorpe was saying. The point that didn't actually arise in Ray B. That's what he's saying. It didn't specifically concern directly that matter.
Yes, indeed. My Lord, that is plainly right. The issue was brought before the court almost by a side wind by the Children's Guardian team. But it is very much the focus of both Lord Hoffman's judgment and Baroness Hale's judgment. And I think, my Lord, that might bring us on to the perception that the judge at first instance had, Her Honour Judge Kushner.
Yes. So we're back to the appendix.
We are. It is back in the appendix at page 34, the section that we have just been looking at, and we pick it up at paragraph 2.13. Just to place this in the chronology of events, of course, by this stage, though not at her first fact-finding judgment, the first instance judge had the benefit of the House of Lords judgment in Re B. She hadn't, prior to the application by counsel to look at her findings again, had that opportunity.
Yes.
At paragraph 2.13, the judge says this, specifically dealing with the arguments, and it is plain, if we may shortcut this a little, it is absolutely plain from Miss Case's skeleton arguments that both those passages that we have just looked at, and that passage of Lord Hoffman, deals with that Lord Hoffman speech, which doesn't in fact address She says at 2.13, Miss Case sought to call on the passage in Lord Hoffman's speech to indicate that the ratio of this decision was to be imported into the separate consideration of decisions as to who was the perpetrator of. And then that extract that we just looked at is set out with the judge italicising the very last sentence there. The fact is, the judge is italics, that one of them did, and the question of the tribunal is simply whether it was probable that one rather than the other was the perpetrator. The judge goes on, this is how she deals with it, taking out on the face of it, she says, this particular sentence would appear to advocate the, in quotes, beauty contest approach to deciding which of two possible perpetrators should be adjudged to be the actual inflictor of harm, namely to decide simply which was more likely on a balancing, and then she adds a or percentage basis. The other suspect would therefore be adjudged to be innocent and therefore absolved, almost exactly stating the test that is to be applied, but then going on to say, however, this sentence is almost a passing comment in the context of the real issue in the Re B case. It could by no means be regarded as anything more than obiter, says the judge. Further, although I do not know whether the other case law with which I will deal below was before their lordships in Re B, the judge must then, I pause to say, just have had a transcript and not a proper report setting out the authorities quoted and referred to. It certainly did not form part of their reasoning in that case. And then she goes on, if we may just conclude it with this final paragraph at 2.16, to say, it has long been...
Sorry, which paragraph?
2.16, my lord.
Yeah.
It has long been acknowledged... It has long been acknowledged that unlike an absence of a decision as to whether there has or has not been significant harm, it is well within the ambit of reasonable conclusions for a judge to be unable to find on the evidence that one or other of two or more possible perpetrators actually caused the harm to the child. My lord, we say that the judge in that paragraph goes off at a tangent and misinterprets Lord Hoffman's speech. It is, we would emphasise, no part of our case at all to suggest that where there are only two perpetrators in the pool of perpetrators, that Lord Hoffman's speech, or Baroness Hale's speech for that matter, should be construed as saying that the judge has to decide between the two. That, if we may say so, requires an almost willful misreading of those two speeches. And in that, we entirely agree with the analysis of the Court of Appeal in Re D.
So is there anything wrong with paragraph 216?
Only in that it seems to be...
It seems to be correct.
Well, the judge there seems to... It has long been acknowledged, she says, that unlike the absence of a decision where there has or has not been significant harm, it is well within the ambit of reasonable conclusion for a judge to be unable to find on the evidence. So she states the position as we say it is.
Right.
But
correctly.
She states it correctly, but, my lord, she seems to be stating that as some kind of interpretation of what Lord Hoffman is saying at the quoted paragraph at the top of the page. That's the link we say that the judge is making there.
But there's nothing in Lord Hoffman's speech which suggests judgment or speech which suggests that paragraph 216 is wrong, isn't it?
Yeah, absolutely, absolutely right, my Lord. There is no obligation on the judge to determine between two perpetrators when there. May we just look briefly at D then, because we entirely associate ourselves with the reasoning of the Court of Appeal. Is it helpful to do so, my lords?
Well, in a sense, it arises out of the discussion that we had earlier.
Precisely so. It was my Lord Brown's point.
Yes.
Yes.
It isn't essential for the purpose of establishing the case to identify a perpetrator, and therefore the running down cases that say that the judge has got to make up his mind which of the two drivers was to blame for this crash in the middle of the road don't apply. But that, of course, is, you would say, I assume, beside the point.
Precisely.
Because what she should have been asking herself is, on the test laid down in Re B, can I or can I not make up my mind?
On the balance of probabilities, does the evidence here, properly analysed, indicate that either A or B, mother or father, was the perpetrator? May we just look at Re D?
It's probably the perpetrator.
Probably the perpetrator.
But that, to my mind, is what she's saying in paragraph 216.
Yes, the judge is certainly saying there that it is well within the ambit of the judge to come to a conclusion that she can't determine between either, and that is undoubtedly right. But she seems to be saying that. If we just look at the passage she's italicised at the top of the page in relation to Lord Hoffman's speech there, the fact is that one of them did, and the question for the tribunal is simply whether it's more probable that one rather than the other was the perpetrator. So she seems to be interpreting Lord Hoffman's final comment there as an obligation to determine between two perpetrators, rather than addressing the centre of the speech, which identifies that the test to be applied, not obiter at all, but directly relevant to the judge's speech, is the balance of probabilities when it comes to identifying the question of perpetrator.
I take it you're going to come on to take us through how she actually goes about the exercise, because that's the best guide to what she was really thinking about.
My Lord, I certainly am, and I'm going to take, my Lord, to the judgment, then to the application that was made by Mr. Rowley, then to the adjunct to the judgment, and then to, briefly again, to this final judgment where she tells us what she was doing.
But I mean, Mr. Hayden, as I understand it, in B, I mean, the House was extremely critical, understandably, of the trial judge for simply not doing what, as Lady Hale was saying, you know, what judges up and down the country have to do every day of the week, make their minds up and decide, yes or no, on the balance of probabilities, is this through the threshold, is this an abused or whatever it is, ill-treated child? Yes. And the judge jolly well has to do that.
Quite so.
But I mean, are you saying that B is putting remotely that same sort of pressure on the judge when you have two or more candidate perpetrators, likewise to go through that same process? Is the judge under the same duty to come off the fence?
Where it is possible to identify a perpetrator, where the evidence supports it, the judge, we say, has an obligation to analyse and sift that evidence so that the clearest possible factual substratum can be identified for future planning for the children.
In other words, indeed, the judge has to decide whether he or she can come off the fence.
Precisely so. And if it is maybe have a look at the judgment of Lord Justice Wall in D, because it addresses some of my Lord Brown's points. Many of these cases present a similar scenario from a number of different perspectives. This case concerned a young child.
Sorry, where are we going?
I'm sorry, forgive me. It's Reedy tab 1 in volume 1.
This is what is set out at some length in the first respondent's case.
It is at some length, and therefore we must deal with it.
Yes, thank you.
Saying that, we, as I have just said, agree with everything that is said in here. There's nothing in dispute with the respondent's case on this point. We make it absolutely plain, I hope, that there is no obligation to choose between two perpetrators. This was a 10-week-old child found to have a number of injuries, and the focus of the case was the fact that the mother had, in the course of cross-examination, admitted to having probably caused the injuries to the child's frenulum. The judge excluded the mother as perpetrator, noting in her judgment, Judge Plumstead, that it was better to identify one of the parents as the perpetrator than to leave an unsatisfactory state of uncertainty. The father appealed, arguing that the mother was the sole perpetrator on the evidence. The local authority and the guardian argued, as they had done at first instance, that neither parent could be excluded as a possible perpetrator, and the Court of Appeal held, substituting a finding that neither parent could be excluded from the pool of perpetrators for the injuries, and remitted the case for clarification to the judge. The significance of it, my Lord, is at paragraph 9, where Lord Justice Wall looks at precisely the point that Lord Clark was raising. Re B, Lord Justice Wall says, of course, establishes that the standard of proof to be applied to all findings of fact in care proceedings is the simple balance of probabilities test. And at paragraph 10, the first point is that the court is not required to identify a perpetrator, simply because, as Lord Hoffman graphically puts it at paragraph 15, if, for example, it is clear that a child was assaulted by one or other of two people, the fact is that one of them did, and the question for the tribunal is simply whether it's more probable that one rather than the other was the perpetrator. We do not resile from the propositions stated by this court, paras 55 and 56 of its judgment in Re K, which are helpful to look at. As a general proposition, we think that it is in the public interest, and this is back to my Lord Brown's point, it is in the public interest for those who cause serious non-accidental injuries to children to be identified wherever such identification is possible. It is paradigmatic of such cases that the perpetrator denies responsibility, and that those close to or emotionally engaged with the perpetrator likewise deny any knowledge of how the injuries occurred. Any process which encourages or facilitates frankness is accordingly, in our view, to be welcomed in principle. As a second background proposition, we are also of the view that it is in the public interest that children have the right, as they grow into adulthood, to know the truth about who injured them when they were children, and why children who are removed from their parents as a result of non-accidental injuries have in due course to come to terms with the fact that one or both of their parents injured them. This is a heavy burden for any child to bear. In principle, children need to know the truth if the truth can be ascertained. And Lord Justice Wall then goes on, we do not think that there is anything in these two paragraphs which is in any way inconsistent with the speeches in the House of Lords in Re B. The crucial phrases are the two paragraphs we've cited from Re K, wherever such identification is possible and if the truth can be
Now, is that
ascertained.
exercise any different from the exercise required by section 31 subsection 2 itself? In each case, the court has to be satisfied on the balance of probabilities, and implicit in section 31.2 is precisely the same, surely, namely that the court can only be satisfied where it is possible to be so satisfied, or where it is possible to However he put it in the next paragraph.
Precisely.
So it's exactly the same exercise the court is on, though the question is different. Is that
The
right?
question different, the exercise is the same, the test is the same.
I mean, if you can't be sure on the balance of probabilities at the first stage, you don't get through the threshold, end of story.
If you don't get through the threshold, that's the end of the story.
End of story. Whereas at the second stage, if you don't get through the threshold, if you can't decide it on the balance of probabilities, the result is that more than one candidate perpetrator is left in the frame.
Yes, I've stopped at the judgment at precisely the point that Lord Justice Wall answers that issue. May I just conclude it?
Yeah, absolutely. I was reading ahead.
I entirely accept that. I wasn't suggesting that wasn't the case.
Yeah.
Yeah, so would you like to read on?
Yes, forgive me, I'm just lost my place.
That's just
Yes.
above the break, isn't it? If such
Yeah.
an identification is not possible, I think that's where you've got.
Yes, precisely. If such an identification is not possible, because, for example, the judge remains genuinely uncertain at the end of a fact-finding hearing and cannot find on the balance of probabilities that A rather than B caused the injuries to the child, but that neither A or B can be excluded as perpetrators, it is the duty of the judge to state that as his or her conclusion. To put the matter another way, judges should not, as a result of the decision in Re B and the fact that it supersedes Re H, strain, and this is the nub of it, my lord, strain to identify the perpetrator.
Do you accept that?
Absolutely. There is nothing in this speech that we in any way depart from.
But I mean, I do think, I thought B suggests that judges should strain in order to decide the first question, the threshold question.
Re B suggests in terms that judges should do no more than their jobs, to look at the evidence, to sift and analyse the available evidence and come to the conclusion that a proper analysis of that evidence permits. It doesn't suggest that they should strain to make findings when the evidence doesn't
I
support
think
it.
at Ray B, the feeling was the judge had done everything in his power not to come to a conclusion.
There was a certain
That was the real problem.
there was a certain artificiality about the construct of that first instance judgment to test propositions, I think, was the feeling.
The passage which was quoted in bold by, which we saw in the judge's opinion at page 35,
Yes.
Shouldn't be read then as suggesting that any other test is to be applied. I mean, the balance of probabilities test is all the way through the thing, isn't it?
That Judge Kushner was adopting of that final paragraph that is picked up in Read D and comprehensively deconstructed.
Just one slight point.
Yes.
I noticed that Lord Brown, no doubt by mistake, said sure on the balance of probabilities.
Oh, I didn't notice that.
And I noticed the words genuinely uncertain at the end of a fact-finding hearing and cannot find on the balance of probabilities. One has to be very careful, doesn't one, not to introduce beyond reasonable doubt into balance of probabilities.
Yes.
All of these phrases can be understood. It's understandable why people use them and so on and
Yes.
so forth. But it is quite easy to slip into.
It's very easy, and we'll go on in due course to look at a distinction between probability and likelihood recently made by Lord Justice Wilson in Re T, which puts that difficulty of language in this area into very stark focus indeed. But it is clear nonetheless what Lord Justice Wall is saying, even if there is a lack of felicity of expression from time to time. May we just conclude that section over the page at paragraph 3. The essential findings made by the judge, although not recorded in the order of the court issued on the following day, were that the father was the perpetrator of the injuries suffered by both children, the injuries to S being more severe, and the mother could be excluded as a perpetrator. It was not suggested that any person...
Where are you reading?
It's paragraph 3.
Paragraph
in
3.
D, second page, top of the second page in Ray D.
I'm sorry, my lord.
I'm right. We're looking at it.
I shouldn't have. Can I just revisit that? I've gone to the wrong page.
My fault, I put you off your stride.
No, I've started at the wrong passage.
Just tell me where we are and I'll...
If we go to paragraph 12
What
of the judgment of D that we're looking at, it's
Yes.
page 2, and then turn over the page to the top. That was the paragraph that I was searching for.
You were in the wrong place.
I was.
Yes, sorry, so was I.
I was on the top of the wrong page. Just picking that up, the fact that it's so strained to identify the perpetrator we were looking at of non-accidental injuries to a children. If an individual perpetrator can be properly identified on the balance of probabilities, then for the reasons given in K, it is the judge's duty to identify him or her. That was precisely my Lord Brand's question. It's the judge's duty to identify him or her where the evidence supports it. But the judge should not start, and this again is important, the judge should not start from the premise that it will only be in an exceptional case that it will not be possible to make such an identification. There will inevitably be cases, of which this particular case was one, where, in our judgment, the only conclusion which the court can properly reach is that one of the two parents, or both, must have inflicted the injuries and neither can be excluded. So, having identified that that first issue in the identified issues was a matter of total agreement amongst the advocates, I hope we have now demonstrated that whatever the perspective of Judge Kushner or indeed Lord Justice Thorpe, it is clear that the test to be applied is the balance of probabilities when seeking to identify a perpetrator, and that a court does not need to strain to identify a perpetrator, and there will be cases where the court cannot on the evidence available to it.
Yes. Just looking back to page 34 in the appendix, if we might, to paragraph 2.11
Yes.
of the judge's opinion, am I right that she has actually correctly picked up the impact of Ray B? The last few lines.
Yes, she's picked up the impact of Re B as to the threshold criteria,
Yes.
but not picked up its impact in relation to the identity of the perpetrator.
Right.
She has appreciated there that the House was saying in Re B that the heightened cogency test isn't helpful.
Yes.
Well, is it helpful to prove any fact on the balance of probability?
I don't think, with respect, that the judge has gone on to apply that to the question of perpetrator. She can't have done, because that would be inconsistent.
That may be so, but as formulated, she's correct.
Well, as far as she goes, yes.
I mean, don't we have to look on to part 3, 3.1, 3.2 and so on, 3.5, where she actually tells us what she's doing?
We are going to go on to that.
Yes, I was thankful because I took you back to that. And I think earlier I'd asked whether you were going to take us through to see how she actually did it.
That is the end stage of the judge's thinking.
Yes.
We have the judgment, we have the application made by counsel, we have the adjunct judgment, then we have the clarification.
And where is the error in part 3? Where is the error? Is it 3.5? Where is the error? You say, where does she go? Where can we see her applying the wrong test?
It is impossible to say whether that is an error without contrasting it with the actual exercise that she undertakes.
I'm looking at it.
What we will say, in due course of the is series of impressions for which should findings, looking at propensity or surrounding circumstances. What she does is a thoroughly sound job, actually analysing the evidence, the real evidence, not something below evidence that was before her in the case. Well, maybe come back to that.
Are you saying that we need to go back to what she actually did in April?
Yes.
Rather than her account in January of what she had done in April?
Yes. January is an ex post facto rationalisation of what happened in April. Then, of course, with the benefit of the House of Lords decision in Re B, which was not available to her when she gave the April judgment.
My understanding was that paragraph 3.1 at page 39 was referring back to what she did in April. I made my findings.
Yes. It is. As we say, it's an ex post facto rationalisation of what she did on the 3rd of April.
If she did what she said on page 39, would that have been all right?
If she had been unable to find the perpetrator to the requisite standard of proof, of course this is not our case, but if that is taking Milor's hypothesis, if she had been unable to find the perpetrator, she would have been entirely right to communicate her impressions as to those areas that best feed into the assessment process. She would, in our short submission, have been entirely wrong to start commenting on standards of probability or likelihood below the civil standard for what can that possibly mean, and wholly wrong to start talking in percentage terms. Both are dangerous, both are unhelpful, both are a danger to shipping as far as subsequent assessments are concerned. But Lord, I hope to place that judgment, if I may, in its proper context, because it I think is helpful to look, again, following, if we may, Lord Brown's chain of thought, to look actually what it is that is hoped to be achieved in the fact-finding exercise, how it ought to be conducted, how it ought to be focused, and what its advantages can be, because it's in that context that we are considering the whole issue. I think I can properly take this relatively briefly.
In our case, we have explored the genesis of the split hearing. That was with the Children Act Advisory Committee in 94-95. It came into the law, the case law.
Miss Judd will remember my conducting just such a thing in 94. I don't think it was invented in 95. She has a very clear recollection of it.
I had a feeling that was a hostage to fortune. But
we conducted a fact-finding hearing about whether a little boy's injuries were non-accidental, and indeed about who had caused them 3 months after.
Well, my lady, the first trace we could find of it was in the Children Act Advisory Committee report, which was 94. Then the first reported case that we could actually find was Mrs. Justice Bracewell. But the whole concept finds its fullest expression in CB and JB with Mr. Justice Hall, and that's the starting point.
Well, I think the second sentence of your first paragraph is probably safe enough, which is just explaining the genesis of it. It evolved from the task that was required to be performed by the 1989 Act. And, one can follow that easily enough. Anyway, you've set out the history. Do we need to go into the history very much?
No, I'm going to fast forward from the history, if I may, and go straight to the very crisp guidance that Lord Justice Wald gives us in CB and JB, which is at tab 10 in bundle 1 of the authorities. May we ask my lords to turn to the fourth page in? I'm afraid there are no paragraph numbers here.
Fourth page in.
Fourth page in.
Yes.
And towards the top of the page, it says, the lessons to be learned from this part of the case are, in my judgment, the following. Do you want to have that? Yes. Where the court, as here, decides that a factual issue or factual issues in a case are critical, the court, taking it shortly, should identify them, maintain their focus on the factual issue or issues, and not allow themselves to be diverted from them with very good reason. Two.
I'm sorry to be so slow. Can you just tell me exactly where this is? Is it before you get to questions raised by the case?
It's just after that, on the top of the opposite page. I think my lord has it there.
I see, yes.
I think my lord has
Thank
it,
you very
yes.
much.
The essence of a split hearing, number 2 we're on, my lord,
Yeah, thank you.
is the clear identification of the issue to be tried. 3, the importance of keeping the eye on the ball, firm timetabling. And then 4, an important one, evidence which is relevant to the assessment of the parents or other family members if and when the threshold criteria are established should not be permitted unless for some reason it is of direct relevance to the factual issue being tried. And this is, we submit, the important principle behind the whole fact-finding process. It is the essence of a split hearing that assessments of the parties and their capacity to parent their children need to be carried out on the basis of the facts found by the court. Ex hypothesi, that can only be done after the court has decided both that the threshold criteria have been satisfied and the factual basis upon which they have been satisfied. Evidence of propensity is unlikely to be helpful in the resolution of a factual issue.
I've got some difficulty with that statement, but I think we've got enough to think about in this case without diverting ourselves into the admissibility and relevance of propensity.
That is a very controversial issue. Quite what is meant by propensity, we will see in some cases judges actually not through common sense, but through their own evaluation of the
Well, if similar fact evidence is relevant in criminal cases these days, why isn't it equally relevant in child protection proceedings? Not to have regard to, for example, the fact that a man or woman may have been convicted of it, and that is the case. Whether or not convicted of it, if the facts can be found.
If the facts can be found again, but for convenience, if the conviction is established.
Can I be quite clear where we're going on little 4? Is the second sentence, the essence of the split hearing and so on, is that, do you accept that proposition? Facts found by the court.
We accept everything here, save for the rather controversial points of
Yes, I follow that, but yes.
That's 4.
All right, yes. Yes.
The point we're making, the simple point we're making, is that what Mr. Justice Wall is doing here is establishing absolute importance of the clearest possible factual substratum so that future assessments can be based on a clear understanding of what the judge has found, so that when the judgment comes to be considered by the parents, by anybody else who may have been in the pool of perpetrators, by the social workers, by the psychologists, that they are all able to see from the judge's findings the factual substratum upon which the welfare analysis thereafter will be predicated. And most importantly, as important as the findings themselves, because they all have exactly the same basis in the future.
Part of the object of the exercise may be, may it not, to get over a blockage of denial.
Absolutely.
Denial that the injuries are non-accidental at all. So you have clear findings that, yes, these injuries, or these particular ones of the injuries, are non-accidental. That's number one. But it may also be to get over a blockage of denial in relation to the perpetrator, because if the court can decide who the perpetrator is, then people can start saying, well, let's work with that.
Yes.
Let's find out, let's acknowledge that and move on and find out whether we can work with you to minimise the risk and put in protective mechanisms and so on.
To put it in practical context, if a parent is being assessed, there is nowhere after the fact-finding judge before the parent if he has been identified by the judge. He is the perpetrator. The denial is no longer helpful. The paradigmatic scenario, usually we may say, not that there is full acceptance of the finding. No. Rarely is that the case, sadly. But there is often some movement towards accepting particular findings upon which creative, imaginative social workers can work to open up the potential for future rehabilitation. That is the central objective of the fact-finding hearing for the parent, to record the findings and maybe anything else there to help them. It is self-evident, therefore, of course, to say that the language of such judgments trying to communicate a concept of likelihood or probability below the civil standard in those circumstances is thought and in any event unnecessary. Look, Lords, maybe just illuminate something of the judge's own approach to the in that first fact-finding hearing set out in the first judgment.
Yes. So we start there at page 52, do we?
And it is the start that we want to look at for now. We'll come to deconstruct it in due course, but it is the test that the judge is actually applying that we want respectfully to draw my Lord's attention to here. It's halfway down the page, helpfully under the heading test. And our short submission is it's the wrong test. The test I have applied in relation to these findings, and may we just pause there. When the judge refers, as she does there, to these findings, plural, she is not looking at harm, because harm was not an issue in the case. One looks at the chronology of it, shortly before the fact-finding hearing. The second report of the haematologist, Dr. Wills, arrived, and the mother abandoned hope thereafter that there might be some medical explanation for these bruises seen on Jay, and the position of the mother, and indeed of every party before the judge at the fact-finding hearing, was that these injuries were non-accidental.
So we've passed the subsection 1A threshold, is that right?
What you've got is a concession that this child suffered significant harm as set out in the medical injuries, and that was attributable to the care given to him.
Yes, because he would have suffered significant harm whether they'd been accidental or non-accidental.
Precisely.
But the important point was whether they were attributable to a lack of proper parental care.
Precisely so. And the mother is no doubt properly criticised for arriving at that realisation, late in the day, waiting for that very last piece of medical evidence to come in before she conceded that this was non-accidental injury.
Yes.
But the point here, of course, is that when the judge says, the test I have applied in relation to these findings, the findings that we are looking at are essentially the question of perpetration.
I only raise this because it's in the Statement of Facts and Issues, paragraph 21. As an issue for determination at the finding of fact hearing, 1, did Jake suffer NAI? But you're saying that wasn't an issue.
It had been conceded.
So you're saying that that wasn't an issue. Well then, we have to correct the Statement of Facts and Issues.
No, that was
What had been identified to be dealt with at the hearing, but it didn't have to be addressed because of the mother's concession. There's no doubt but that the mother conceded this was non-accidental injury, and the only issue for the court to consider, essentially, was this difficult issue of who was the perpetrator. So that when
or I suppose, who were the perpetrators?
It's correctly identified as a question at the top of page 53, but the answer was yes.
It wasn't litigated. The question was properly raised. It was there. It was the position of the mother until Dr. Will's report was received. By the time of the hearing, the concession was made. So there didn't have to be any medical evidence. The evidence focused entirely on the factual issues in play. And so when the judge says, I've applied to these findings the test in the House of Lords, it is to the question of perpetrator that she is applying this test, and the test that she is applying in our submission in the clearest possible terms is the heightened cogency test. The allegations in this case are very serious indeed, says the judge.
See, Mr. Hayden, I've worried about that in this case.
The injuries.
Clearly, any bruising to the face of a baby is serious, important, and a matter of concern. But most of the child abuse cases that I tried, and I tried a great deal, the injuries were far more serious. I mean, leagues ahead of these. Fractures, head injuries, very painful injuries.
Yes.
Injuries inflicted at different times.
Yes.
Or sex abuse of the most unimaginable sort. This isn't in that category.
Milady,
Slightly bothering me about this
Milady,
case.
if I was confident of nothing else in this appeal, it was that question would be raised, and equally that Milady would raise it, if I might say so. They are not the most... There is an index of gravity to every injury to a child, and it's always difficult to say that bruising, as extensive as this bruising was to a baby just under 4 weeks old, is not serious. Plainly it is. But it does have to be located in its index of gravity, because sadly we see many cases, as Milady has just outset, where the injuries are infinitely more serious. Broken bones, attempted suffocation, torn frenulum, subdural hemorrhages, retinal hemorrhages, etc. And on that scale, this is at the lower end of the scale. What matters, of course, is that the judge fixed it there in order to indicate the commensurate degree of proof that was required in order to establish the perpetrator.
So she's saying the allegations
are very serious indeed. She is saying the allegations are serious indeed. May we look at the whole of the sentence, because we have to. I think I anticipate my Lord's point on it. But may we just say this, just to conclude Lady Hale's point. They are not the most at the most serious end of the spectrum, but nonetheless, in relation to a baby of less than 4 weeks, they are very serious, because as Milady will recall from first instance cases, these are so often harbinger injuries of a subsequent and even more serious assault, and that's the difficulty. that is
In what
faced.
respects were they very unusual?
I don't know.
Well,
I don't know.
perhaps it's the age.
She may have been getting at what we have just been discussing.
Yes.
The arm injuries were unusual, weren't they?
Well, pinching is suggested. It's a very curious
weren't pinch marks.
idea.
They weren't easy to. It wasn't. I suppose we could say that it was not easy, absent a reliable history, to understand how the bruises had come about in particular locations on the child's body. But, my lord, I wondered. I'm bound to say what the judge meant by that observation, and I don't know the answer to it beyond that speculation.
Yes. I just wanted to make the point that I don't think, to be fair to the judge, she was saying the injuries in themselves were very serious. It's the word allegations is no doubt carefully chosen.
The point of it, though, ultimately, in this paragraph, is it illuminates the thinking as to the test the judge was applying.
Was that the test that was common ground before the judge?
My Lord, we have to remember when we're looking at this judgment that we are pre.
I quite understand that, and what's the answer? It was common ground because that was the test.
It was a widely held view. Yes, I think it would be overstating.
But did anybody argue before the judge that it was the wrong test?
Nobody would have argued before the judge that she was applying the wrong test.
And were the questions those identified by the parties for the judge to determine?
No, I've been unable to trace those questions in the order, but nobody disputes that those were the right questions to be asked. There ought to be an order setting out in advance to focus the party, but I haven't been able to trace it. Miss Grocott thinks she's found it. The allegations in this case are very serious indeed, and in many respects also very unusual. When I apply the appropriate standard of proof, it has to be based on evidence of reliability and cogency equivalent to the gravity of the allegations. My Lord, it is plain as it could be, we say here, that what the judge is doing to what was the central issue before the question of who was the perpetrator, was applying a heightened cogency test to that issue.
Yes, it's why paragraph 2.11, which we were looking at earlier at page 34, is so interesting, that she's picked that very point up.
It is an ex post facto rationalisation to say what's going on, but here in the primary document it couldn't be clearer.
Yes.
So Mr. Pikestaff, we say, that she was applying a heightened cogency test, having considered, and this is the significance of the remark in relation to the injuries, have considered them to be very serious indeed, and therefore requiring evidence commensurate with what she perceives to be the seriousness of the allegations. It is the heightened cogency test that is being applied, and we know, and we've now seen, that is the wrong test.
And was this point argued in the Court of Appeal?
We say it was made.
Sorry?
Yes, the Lord,
it was.
And we say furthermore, we develop it further than that. We say that even if the judge hadn't expressed herself in that clear manner, the whole logic of her reasoning during the body of the judgment is consistent with it. Yeah. And would indicate that was precisely
what did the Court of Appeal say about that, this point?
I don't think it's addressed in the judgment.
No, I couldn't.
No, it isn't.
And you say that would be enough in itself, do you?
We say that's, on one, if we're right on this, that's the end of the matter.
That's the end of the case.
The judge, on her own articulation of the test,
if you're right on that, that's
applies the wrong test.
So we don't need to get in on that basis. We wouldn't need to get into anything.
We don't even need to look at all the complications in relation to on certain perpetrators and what language needs to be looked at. If we are right on this.
If you're right on that, yeah. That's it.
And is that what Lord Justice Thorpe meant by a sweeping departure then? Because apparently everybody had interpreted H as requiring that approach, which you now say is fundamentally wrong.
I think that's it. I'm sorry, Marie.
as I understand it.
So you might have used the expression sweeping departure yourself.
Well, it's difficult to find the appropriate phrase. Certainly there was greater clarity brought to the law.
But you're now saying that this decision is fundamentally flawed
Absolutely.
by applying a test which was accepted on all sides in this case and widely accepted as being the test which was said to be the appropriate test after Re-H.
Yes, yes.
And therefore,
Though when one properly analysed Re-H, that wasn't exactly what Lord Nichols was saying,
Well, that
as
may be
so
so.
frequently happens.
Precisely. I'm very grateful for the...
Whatever the explanation of it, that you say it's the wrong test.
However we come to it is the wrong test.
everybody agrees it's the wrong test.
Everybody agrees it's the wrong test because everybody has agreed, for the purposes of this appeal, that the test to be applied to the identity of the perpetrator is the balance of probabilities, nothing more, nothing less, and certainly not this heightened cogency test. And there is the judge, in the plainest of terms, articulating in the prefacing paragraph of the exercise the heightened cogency test. And with respect to Lord Roger, we entirely agree that if we are right on that, in the context of this case, that is the end of the matter. But there is, of course, a mire of confusion now in relation to the uncertain perpetrator cases. And we anticipate that this court would want to bring clarity if it is at all possible.
But in view of what you've just been saying, do we need to explore in any detail the reasoning of the judge in her April judgment?
May I jump forward to that, because I don't want to rest on the basis that I have persuaded the court that what she was doing in paragraph 1 was applying the heightened cogency test, although it does seem to us difficult to argue to the contrary. What we say, that test which she articulates is there in the body of her judgment. One sees, even in this annotated judgment, one sees her applying precisely that test, rejecting evidence that we say is plainly of the quality to establish a finding and failing to draw the conclusions of her own analysis. My Lords, may we go through it very, very briefly, just isolating the points, because it really is unfair to the judge to take snippets of the judgment. Page 44. Father and Kimberley split up in 2006. That's the father's... I'm sorry.
Page 44.
54.
I thought, yes.
54. I'm sorry, did I say...
Yes, well, I was worried you were going to, leaving April and going, indeed.
I'm
Yes.
sorry.
So we're at page 54.
I turned to page 54.
And we can avoid using the full names if we can.
Father and Father and Kay split up in 2006. Following separation, there have been 15 incidents of concern, read D&D, father's other children. A little lower down, on the 8th of May, Kay said to social worker that father had history of violence and was often impatient with the children. Right at the bottom of the page, the couple's friends commented on the way the parents seemed to bicker and horseplay, and then sometimes extended to Mr. S being over rough with Miss B, causing injuries, pain and discomfort. He was rude to her in front of others. Onto the following page, almost halfway down, on the evening of Thursday the 14th of June, the relevant window for the injuries, we pause there to say, the evidence indicates that the mother went to bed very tired. It was therefore agreed that F would get up to attend to J in the night. In the morning, Friday the 15th of June, the father pointed out bruises on J to the mother, so the mother goes to bed. In the morning, the father points the bruises out to the mother. Later that morning, she in turn took J to a drop-in baby clinic that PM to have him weighed, and she, the mother, pointed out the injuries to the health visitor, and the injuries are recorded and referral to the hospital, and the mother takes the child to hospital with F. And we go on from there to page 57, page 56, simply recording the injuries, beginning halfway down with that beguiling phrase in this case: there is a high index of suspicion in relation to the father. First, he was the one who apparently attended to Jake during the night and morning of the 15th of June. 2, there were allegations of inappropriate care of his other children by his former wife, Kay. 3, there was one incident of domestic violence. There was at least one incident of domestic violence by the father against Kay in 2003. 4, the view in 3 has been compounded by the description of him being aggressive under the influence of alcohol. 4, this is an important one, we say. He has not participated in these proceedings after August 2007 and has not attended court. The concern is that he has avoided the court because he fears he would be exposed as the perpetrator of Jake's injuries. I'm sorry we lose quality of the photocopy over the page. That first line reads, the inevitable consequence, it's an important line, the inevitable consequence is that there is an adverse inference against the father relating to the injuries being caused by him. So the father disengages from the court process, disengages from contact, doesn't come to the hearing where this is the issue to be determined, and the judge states in terms that she is making that she is drawing the inevitable inferences, as she is undoubtedly entitled to do, from the father's non-attendance. And then the 5th point, he has given discrepant accounts to the hospital in June 2007 and to the police in interview on the 9th of October 2007 as to the incidents of the 15th of June. And then concluding, we say, illogically, in the light of that assessment of what is not suspicions or something below finding, that which is, as we have seen, good quality evidence upon which to make a decision. Judges in our submission very rarely have that kind of panoply of evidence available to them in these kind of cases. And it's only right that, having looked at the evidence in relation to the father, we should go through a similar exercise in relation to the mother, as the judge does.
Yes.
And we preface that by saying that the evidence the judge identifies in relation to the mother is qualitatively of a completely different and very much poorer complexion. It doesn't begin to compare with the issues that the judge has identified in relation to the father. And that is clear, if we may say so, from the very first paragraph in relation to the mother. Whereas it is true that there is nothing in the mother's history, so there's nothing in the mother's background that causes the judge concern to raise anxieties, there is evidence from friends that she was finding it somewhat stressful in pacifying Jay when he was crying when he had colic. That compared with not turning up to court, allegations in relation to other children, aggressive behaviour in the past, the fact that this mother struggled with a baby with colic is not even in the same universe in terms of qualitative evidence. Of course she was, and the next one, of course the judge said, she was a first-time mother, and this carries its own stresses. Nobody, I'm sure, would disagree with that. 3,
She could be described as winding Jay in a rough manner.
yes. I'm sorry, I didn't mean to miss that out. Yet could be described as winding Jake in a rough manner. In relation to the 14th and 15th, although the mother's oral evidence that she was unaware of the problem with Jake, he had been unsettled overnight. The judge says, whilst herself saying that this is a neutral piece of evidence, it's of interest that the marks of the face are consistent with an adult hand gripping the baby's face, for example, in the course of winding, although this would not point to one parent rather than another. So that's a neutral point, yeah, properly, if we may say so, identified by the judge as such. And then the judge, over on page 59, goes on to identify other aspects of the mother's presentation. Now, these are undoubtedly, if we may say so, proper findings. It is undoubtedly the case that the mother was slow to accept the conclusion of the medical evidence and the view of the professionals that this was truly non-accidental injury. But that doesn't, we say, cast light in the same way that the evidence does in relation to the father.
Well, there are two things, aren't there, at page 59, as we can see. One is a reluctance to accept that the injuries were non-accidental, and the reluctance to accuse the father of having caused them.
I was going to go on to that.
And, I mean, one can understand why a mother would take that position.
She was reluctant to accept that the injuries were non-accidental, and she was reluctant to separate from the father, a not unfamiliar situation, although by the time of the conclusions of the proceedings, my lord will have seen that the judge was satisfied that the couple had indeed separated, but undoubtedly the mother was slow to separate. But that doesn't cast light on the issue of perpetration to the same degree that those factors that the judge has set out in the first part of the judgment do in relation to pointing to the father.
What about the very bottom of page 59? Here she actually takes the child to the clinic.
We have in fact just dealt with that, but she repeats it. She repeats that point. Sadly, although she did take the client to the baby clinic, this does not in itself provide me with sufficient strength to persuade me that she could have injured the child in the first place. She looks at that, and we've just looked at that in another context. Yes. The baby is injured overnight. The father tells the mother that he spotted injuries the next day, and on the same day, the mother takes the child to the clinic and points out the injuries to the midwives, the clinicians at the health centre. You say that points away from the mother rather than to her. But of course, the really big point, the really big piece of evidence that the judge has is the absence of the father. He disengages. He doesn't attend on this issue, this hearing, which is there to determine what has happened to his son and who caused these injuries. He doesn't turn up, and the judge says, as she is entitled to do, that she draws inferences. There can only be one inference to be drawn from that, and a powerful one, if we are looking at this matter, as the judge was not but ought to have been, on the balance of probabilities. And then, of course...
And at this stage, just remind me, it is the case, is it not, that there are still criminal proceedings pending?
Yes, they... I've checked this a number of times. Mullen and Junior's case will conclude when they will remind me when.
October 2008.
We think October 2008.
That was my impression.
When the prosecution decided to offer no evidence against either. Yes, it is. It's at paragraph 36 of the Facts and Issues. This is the point, logically, and I've rather jump to this out of order now, but as we're here, this is the point then, sequentially, where counsel on behalf of the mother come back to court to ask the judge what she had in fact meant by this phrase, the high index of suspicion. And I'm sorry, we have in fact now got the, conveniently we have not now got the transcripts. May I hand them in, my lords? It won't take but a moment to...
Thank you.
2, 3, 4, 5, 6, 7.
Is the conclusion on page 60 that the mother could not be ruled out as a perpetrator based purely on her stress, winding Jay in a rough manner, and refusing to accuse the father, the only items in
the
that?
judge, those are the main planks of the judge's analysis, but she also goes on to include in them the fact that she hadn't separated from the father and hadn't been frank with the social services about her ongoing relationship with the father.
And also her reluctance, if I might add, to accept that these were non-accidental injuries. And that's quite a significant point.
That plays very, very large in the judge's analysis. She describes this as the main puzzle.
Yes, yes.
With respect to the judge, that is the usual situation, more often than not. My Lords, may we turn then to the transcript to pick up the chronology? I think we can properly, without violence to it, take it relatively briefly. This is the application made on the 4th of June, 08. Mr. Rowley then appearing on behalf of the mother. And on page...
So, sorry, this is what, 2 months after the judgment that we've just been looking at?
Yes, the judgment in April, the application in June. The first page, almost exactly halfway down it, Mr. Rowley articulates this as the first question. The first is, he says, following on from the Sheffield case, we've exercised our minds as to what he had in mind by the Sheffield case and think that must be the North Yorkshire case in the bundle. I'm going to invite the court, he said, to expand a little in relation to the likelihood of perpetration as between the parents based on the observations that Your Honour made in Your Honour's judgment at the fact-finding hearing. And then for 8 pages, the court deals with another matter. It deals with future assessment, but returns to the matter on page 9 towards the top. Mr. Rowley then says, but that brings me to the first matter, which is whether Your Honour would consider it appropriate that my invitation at this juncture to clarify whether Your Honour considered it more likely, and I'm thinking of the comments of Lord Nichols in O&N about likelihood as between possible perpetrators, though, of course, one is not able to exclude an individual perpetrator from the pool, as I read Your Honour's judgment, and, of course, I am new to this, having come back into it, he says, Your Honour mentioned a high index of suspicion in relation to the father not participating in proceedings and the adverse inference which Your Honour drew against the father. The natural reading of that, in my respectful submission, is that Your Honour considered it more likely that he was the perpetrator than the mother. So Mr. Rowley puts that in terms that the judge has in fact considered it more likely that the father was the perpetrator than the mother. The answer to that from the judge is yes, but that by no means, she says, it's not one of those cases when by dint of timing only leaves the mother in the frame. We say this exchange really does illustrate the high test that the judge is applying here to the question of perpetration. That was not my approach at all, Mr. Rowley, indeed, and the judge said she has all the surrounding circumstances. Lord Collins's point from a moment or two ago, finding herself in the position of being rough with the child and inflicting these injuries. Then, in addition to that, you have got to ask, why should she protect the father in circumstances? So, if you ask me to say who is the more likely perpetrator, I would say that the more likely perpetrator is the father. We pause there to say, what can that mean if the balance of probabilities is the test? what can the judge mean there other than that on the balance of probabilities the father was the perpetrator?
Well, I wonder whether it means that if you're addressing the question in isolation, was the father the perpetrator? Surely it's open to the judge to say, well, I have not been sufficiently influenced by the evidence to come to a conclusion on the balance of probabilities that he was. On the other hand, if two people are identified as the inevitable perpetrators, and I'm asked the question, which of these two is more likely to be the perpetrator, the intellectual exercise in answering that question is quite different from the first, isn't it?
It's a very difficult construct because it imports two concepts of likelihood. Likelihood on the balance of probabilities and some concept of likelihood below the balance of probabilities. And what then is it to mean? What is it to mean for the assessors? The judge hasn't rooted this particular finding that the father is the more likely perpetrator in recognised evidential principles, that's to say the balance of probability, but at some test lower than that. What are the assessors? What are the parents? What are the social workers supposed to make of that in future assessment? Why is it anything more than a judicial suspicion, a judicial feeling, an impression, to use Judge Kushner's words? And if so, what are those in the future to make of it? How does it establish the kind of factual substratum that we say is so crucial to the whole process of the fact-finding hearing?
Well, I can quite understand how it may create difficulties for those who have to act on the judgment. But my simple point to you is that you cannot equate the intellectual exercise performed by the judge here with a conclusion on the balance of probabilities that the father was the perpetrator, because she was asking herself a different question, or rather, she was being asked a different question.
We'll look in the adjunctive judgment at the question she perceived herself to have been asked, which may be a different matter.
Yes.
But, my Lord, we do say this, that there is a kind of logical integrity to this, a kind of logical sense. If, as we submit, the judge is applying the heightened cogency test as the framework for the exercise, then to give an indication on the balance of probabilities, that, we say, is what the judge is doing. She's set herself the high bar of the heightened cogency test, and she's answered the question short of the finding on the balance of probabilities. That's what we say is, in truth, has gone on here. And it's not without... There's not a lack of precedence for this approach we see in reading. Doing precisely that, and doing it in express terms. Let me just illustrate that. This is the approach that might have influence and it illustrates that the judge was not alone in this kind of thing.
Is it 16?
It is, thank you.
In volume 1? Thank you.
I don't think we need to write a second in its context. Paragraph 38 is self-done.
This one that went to...
Paragraph 38.
Is this the one that went to the Lord? Or is this
This is the case. This is the Court of Appeal, which subsequently went to the House of Lords. Yeah.
I see.
Right. So we're looking at paragraph 38.
We are. It's just an illustration of Judge Kushner's approach, as we identify it, being undertaken in a different context. Of course, in the case of a single possible perpetrator, there is no doubt that in deciding whether or not he or she is responsible for a physical assault, the court must apply the civil standard, and then the key phrase, elevated in accordance with the guidance given by the House of Lords in Re H. Of course, there was evidence of sufficient cogency to lead to the conclusion that KR was a perpetrator, but was there cogent evidence that he was the sole perpetrator of all 94 injuries? In situations like this, Lord Justice Thorpe says, the trial judge in the family division is similar to the position of the judge and jury in criminal proceedings. There, when both parents stand in the dock charged with the infliction of injury on a baby, and when their defence is either each to blame the other or to offer no credible explanation, how is it possible to determine which is guilty? The same sort of dilemma faces the judge in a situation such as this, where it is incumbent upon him to apply the elevated civil standard of proof. A degree of heightened cogency is necessary. My lords, there's the precedent, we say, for the application, in the clearest possible terms, of the heightened cogency test when considering the issue of perpetrator. That's what Judge Kushner was doing, absent the advantage of Re B.
It's funny, isn't it? It almost produces the reverse effect. A degree of heightened cogency is necessary to enable the judge to say it could not possibly have been the mother.
It's all the sense that the burden of proof is reversed. Coming back to imposing upon the parents, we need to ask too far, but it's certainly setting an unrealistic standard of proof in these cases.
Well, it depends if he's right about what's meant by heightened. I mean, that analysis suggests that he's equating it to the criminal standard. Whereas I don't think that's what an ordinary sort of position was, applying the old case of like Congo and New Bedford.
Yes.
It's more sort of wishy-washy approach. There'll be more problem if it's a serious. There was always very, very difficult to know what to do.
Exactly. Yeah. And the trouble with this case is there was absolutely no doubt this kid had suffered all these horrible injuries.
Yes.
So,
well,
You say this is a case, do you, this is a single possible perpetrator case, do you?
yes. In our case,
That depends upon the sentence in the judge's judgment. Is more likely to be one than both.
Yes, it's not convenient to the wider issues, but our primary position, as we said at the beginning, is that this isn't truly an uncertain perpetrator case at all, because had the judge applied the correct test and followed through the logic of her own analysis, she would have identified the father as the perpetrator.
That's not the question of whether there's more than one perpetrator.
As the perpetrator. Yeah.
But applying the test that she did and saying that it was 60% likely
Yes.
that the father had it caused the injuries, that's an a fortiori case.
Well, that's our understanding of what the balance of probabilities means. And I was just going to go on to the adjunct to the judgment now, if I may.
Is there anything more in the transcript? Was anything said on the other side?
I'm sorry, my lord properly pulls me back. Yes, I think perhaps we'd better. I'm very grateful, my lord. I think we should better.
2000.
So we're going back to the.
I've moved on.
Can you just catch
I've
just
moved
before
on
you,
to
just before you go there?
To be clear, what we were just looking at Ray B non-accidental injury, a 2002 case.
Yes.
What did that become, did you say?
It was one of the two cases that went to the House of Lords that became Re B, Re O and N. It's there in the.
It became what?
Re B, Re O and N. Lords, it's
Ray O and N. It's Ray O and N.
Is it tab 8?
Oh dear. Oh, I misunderstood you. I thought it was
No.
tab 3.
No,
No.
I'm sorry, no, it's a different
No,
reading.
Yes.
Rio and
Yes.
Dan.
Yes.
Yes,
I'm
exactly.
sorry.
Yes.
There were
and
two
Rebe- yes, of course.
conflicting decisions in the Court of Appeal,
Yes.
if I remember aright. And they both went to the House
Yes.
of Lords, and they're reported as Re O and N.
Yes.
Yes, that's right. So there we are. It's,
Although I think that it was Re B that won. Well,
Yes.
neither exactly.
I'm
Neither
sorry,
exactly.
I should have appreciated
Yes, I see.
I take my Lord Clerk's point. We should finish that exchange between Mr. Rowley and the judge before we move on logically to the adjunct to the judgment. We'd stopped at the point where the judge said, I would say the more likely perpetrator is the father.
yes.
Then she goes on to say, yes, but she is not only at the 10% likelihood of being the perpetrator, Mr. Rowley, no. I mean, she is at the 35 to 40% sort of level, I'm afraid. This is the sort of thing I had in mind, and that is no way out of the woods, nowhere even approaching it. No, Your Honour. And then the judge says, I know you're a realist, Mr. Rowley. I was not suggesting that it gets her out of the woods, says Mr. Rowley, but what it does, and of course what the purpose of expressing a view in relation to that even if it is qualified to the extent that Your Honour has qualified it, is that in itself can be of assistance to those who assess the risk. So Mr. Rowley, they're accepting the legitimacy of the exercise. Well, maybe or maybe not, says the judge. So far as the risk assessors are concerned, that may be one thing. But so far as judges are concerned, we have to be pretty sure that there is no realistic risk. Or a minimal and a manageable risk. Again, we say, further illustrative of just how high the judge was setting the bar. The difficulty is certainly on this. We've got a psychologist. This psychologist has isolated elements of the situation which make it a poor risk. So we just pause there to say, because the case had not originally been identified as a split hearing case, there was in fact, despite Mr. Justice Wall's strictures in CBJB, there was in fact a psychological report available to the court. So perhaps it does test the point that Lady Hale referred to. That, I think, is the conclusion of anything relevant on this point within the exchange. And my Lord, that perhaps is the convenient point to follow to the next logical sequence, which is the adjunct to the judgment.
So just before we get there, we just see where the matter's been left. I mean, we've got these two propositions that, with regret, she can't rule either out as perpetrator, but she takes it no further.
Well, she does. She says...
Of course, she goes on to failure to protect, I know, but...
no, she says in express terms, I would say the more likely perpetrator is the father in this exchange.
She says, more likely perpetrator, as between the two, is the father, which she's expressing it around in percentage terms, orally here. But I can't rule mum out.
That's right.
That's what
Yeah.
she said.
The point we make, of course...
But it's actually implicit, page 9, between G and H,
Yes.
that even if it was only, for example, 20%, 25%, that still leaves mother as an unexculpated potential perpetrator.
Not out of the woods, as the
Not
judge
out of the woods.
said.
Nowhere even approaching it.
Yes. Yeah, precisely so.
No, I was looking back at page 60 in the appendix, of course. I mean, you're taking us back to the adjunct.
Yes, I'm going to the adjunct. To
It's
the
just that where she's left it before she goes to the adjunct is interesting.
Yes, and the adjunct, the exchange and the application has been rooted out by the local authorities team recently, but it completes the picture when we get to the adjunct of the judgment, which is dated the 6th of June. The judge at paragraph 1 sets out what she thinks she has been asked by all the parties to do, although certainly the Guardian disassociates herself with the request. I don't know whether the local authority do or not, but we've seen the exchange, and perhaps that answers it insofar as it is capable of being answered. The judge says at paragraph 1, I've been asked by the parties to assist by indicating my view as to the relative likelihood of the mother being the perpetrator of the injuries to which triggered these proceedings. And I don't think there is anything significant in paragraphs 2 to 6, but then the significant observations that are made in paragraph 7 are these. With this information, and she has just summarised those factors that we've been looking at in relation to the father, with this information, together with his aggressive behaviour at the hospital when Jake was admitted, and his lack of involvement in these proceedings, and with Jake generally since his injury, I feel that I can say that between the two parents, it is more likely that the father was the perpetrator of the injuries than the mother. Well, there were, of course, as we know, only two potential perpetrators in the frame. And then the judge goes on to put it in percentage terms, recognising herself and prefacing the exercise by recognising that the exercise is itself invidious though it is to be too specific, but to help further assessments. I am prepared to say that I feel it's 60% likely that the father injured the child and 40% likely that it was the mother. We simply do not see why that kind of expression can be anything other than a finding on the balance of probabilities.
Well, I just think the judge here, going back to this sort of basic problem, she thinks, I don't know whether she's by this time been moved from the position, but her original position was, as I understand it, was, well, you know, given the father's record and all that sort of thing, if I had to choose, it would be the father. But the trouble is that there's this cogency of evidence point, and frankly, there isn't anything which is she regards as really cogent enough to meet the thing. So it's for that kind of reason that, in the end of the day, she doesn't seem to me to think that there's enough here to justify her using that standard, finding something on the balance of probabilities. And I mean, that I think is what her basic problem is. I mean, if she were applying the correct approach, it might very well be that she would come out where you say.
We say that is fatal to this.
Yeah, I know you do, exactly. I know, but I think the trouble is we're picking at this bit, whereas the whole thing in her mind was that she was applying this heightened standard test.
Yes, I'm advancing all our arguments on the basis here that she hadn't applied anything other than the test in Re B on the basis that we have to meet that case. But that is not the case that we say unfolds here. No. It is the H&R heightened cogency test that she applies. The test was wrong. The exercise was inevitably flawed thereafter, and the assessments were based on a flawed premises and unfair.
But of course she doesn't leave it there, does she? Because she comes back in January with a fresh analysis. And as I think Mr. Justice Bodie is saying, she's really endorsing what she said at the earlier stage.
Yes. Fatal to Mr. Justice Bodie's analysis, if we may say so, is that he hasn't factored in this very point that the test applied is the wrong test.
Yes.
But she applied the same test to the father.
Well, it's the same test in relation to both, yes. It's fundamental to, if we may say so, an understanding of both the fact-finding function and the threshold criteria, that it isn't on sound public policy grounds to be set so high, because that is the vehicle by which local authorities intervene into private life to protect children. To set it too high makes that more difficult. That's the reasoning behind the Section 31(2) provision.
But equally, it shouldn't be set too low. my Lord Roger will recall
Yes, I remember.
that the B case, the main argument that was being presented was that reasonable suspicion was enough.
Yes.
We were saying that.
We are almost at the other end of the spectrum here.
But when the judge got hold of the case again in January,
Yes.
the next year, after B,
Yes.
I mean, why didn't everybody say what you're saying now? You know, which is, this is all hopeless now because it's perfectly obvious that the judge approached the entire thing in the wrong way.
Well, this is when Mr. Rowley dropped out of the case and Miss Case came into it, and we see her putting those arguments at paragraph 2.13. I know my Lord is eager to go to the judge's rationalisation of her judgment at page 39, and it's only fair to her that we do that. What she says at page 39, paragraphs 312, 37, is that the exercise that she had embarked upon was something, to use her phrase at 3.4.
Sorry, where are we looking now?
Page 34.
39. 39.
39. Oh,
39, appendix part 1.
Yes.
I mean, was it put to her, did the parties say, well, it's common ground you applied the wrong test? Now, what about applying the right test?
Well, I don't think it was put to her in terms as stark as that. But
That's what should have happened.
But what is absolutely clear...
Well, that's what should have happened, shouldn't it?
Well, it wasn't...
If it was common ground,
I agree.
but there was a new test, she applied the wrong test.
I agree
The party
with
should have
that.
said, well, now it's common ground, you applied the wrong test, now what about applying the right test?
I agree with that. But what the parties did, and we say that must make the answer to my Lord's question, really, yes, this is what the application was. The parties took the judge to Lord Hoffman's speech, which made it clear that the test was the balance of probabilities. The judge comments on that speech. The parties took the judge to Lady Hale's speech, which made it clear that the test was the balance of probabilities. And as we saw earlier this morning, the judge's response to being taken to the correct test was to say that it was merely obiter and was advocating some kind of beauty contest. And that mustn't have been the main ratio of the case at all. So she was taken to the test. She distinguished it. She had the opportunity to address it, but declined that opportunity.
So that's at 2.14, isn't it? That's the beauty contest point.
That's the point.
Yes. But it's puzzling, really, because in 2.11 she accepts that the cogency idea is gone, but she doesn't carry that through.
Where does she say what test it was she was applying?
She doesn't.
Whereas, if we go back to the point we discussed earlier, it might be said in her defence, whatever she said about obiter, she stated the correct proposition in paragraph 216.
Yes.
But I'm troubled. I'm sorry, I'm jumping around a bit too much, but 4.3 at page 40 troubles me. We're dealing with W, of course, at this stage, but what about the nature and gravity of the feared harm? I mean, that seems to me to be not very far from the cogency idea. And we're looking back at a case in 1996.
Yes, agree.
She's finding it very difficult to dislodge it from her mind.
But possibly there is an explanation for this. We do have to distinguish between the threshold in relation to the two children. And 4.3 is dealing with the baby.
Mm-hmm.
The baby has suffered no harm at all.
All right.
The only question is whether there is a likelihood that the baby will suffer significant harm.
Yes.
And one of the unchallenged findings or statements in the H&R, was that likely, in that context, in section 31.2, did not mean more likely than not.
Yes.
It meant a real possibility, one that cannot sensibly be ignored, having regard to the nature and gravity of the feared harm. But that is, of course, a completely different thing from the factual question of who did what to whom. It's a question of the degree of likelihood that you have to find when you're looking to a child who has not yet been harmed and the question is whether they will be in the future.
Yes.
Yeah.
That's the explanation for her using it there.
Yes, and of course it's under the heading
In relation
Yes.
to W.
Yes,
to
I see.
baby.
Yes, well, thank you very much. Yeah.
So, whatever else one may think, I wouldn't want her to be criticised for paragraph 4.3.
Yes. But the point remains that, that she hasn't actually said what the test is, and we're left wondering whether it isn't the test that she was using all along in the previous hearing in June and the previous that in April.
The very best we can do, that which she writes down herself at page 52.
Page what?
Page 52.
Sorry.
Yes.
Page 52 of the primary judgment, and
Yes.
that is the heightened cogency test, and that is consistent, we say, with everything
Page
else that
52.
we have looked at.
Under word test. Yes, so I mean, unless we can be persuaded that she's retracted that by what she says in page 34,
Page
that seems to
39.
be the test. But the trouble is she hasn't actually translated into a clear and given us a clear indication of how she's revised her test and indeed applied it again in looking at the material in her earlier findings.
The closest the judge comes to precisely that is between paragraph 3.1 and paragraph 3.7 at page 39.
Yes.
That's where the judge embarks upon precisely that exercise, my lord. But what she says is at 3.2, having set out the factors which I did in respect of each of the parents, which we have looked at, I also formed the view that neither could be absolved from being a potential perpetrator. In other words, there was a likelihood in the sense of a real possibility that each of them was the perpetrator or the perpetrator. The allocation of percentage likelihood, she said, is just that, namely an evaluation of the factors which give rise to the relative likelihood or reasonable possibility of each pair of the parents being the perpetrator. And then she says, this is a qualitatively distinct and different from findings on the basis of the evidence. But we have gone through her notes of judgment, and in our submission, what we are not seeing in that is impressions falling short of findings, preoccupation with propensity. What we have actually seen are clear factual findings, as we would hope to find in any judgment, set in the framework of the balance of probabilities. These are factual findings that the judge is making, and to demote them in this way to something qualitatively different from what the judge calls findings on the basis of evidence is simply not doing justice to the judge's own exercise here. She goes on, when one is deciding these issues, a judge frequently reluctantly comes to the conclusion that he cannot decide who is to blame. However, although unable to form a definitive decision to the requisite standard, a judge can still have an impression, falling short of a finding, etc.
You should probably have read paragraph 3.1. Did you read that? Because
I didn't. I made my findings as to the threshold and the question of perpetrator or perpetrators at the original fact-finding hearing. I found the threshold criteria passed on the balance of probability. However, the evidence was such that I could not find it proved against either of the parents. She means there identify the parents, against either the parents that he or she had inflicted the
yes, I see. No, I was wrong. The threshold criteria relates to the question of whether the injuries were deliberate or not.
Exactly
Yes.
so.
Well, you say that was conceded.
Yeah.
The fact of
The fact that
non-accidental...
the threshold criteria was satisfied, you say was conceded.
Well, it's two-part. It was conceded that these were non-accidental injuries and they were attributable to the lack of care given by the parents. That was conceded. That was not an issue even from the outset of the fact-finding hearing. We say the only issue, and therefore this must be what the judge, apologise for repeating myself, this must be what the judge had in mind when she outlines the test, is the question of perpetration. That really, in truth, was the only matter before the court, often the most complicated matter that the judge has to determine, but almost the sole issue forensically.
It might be said that paragraph 3.7 shows that she was still applying the old test, because there it says that the effect of the adjunct was to have made a finding that the father was the perpetrator, and therefore the mother was absolved as a really possible or likely perpetrator also, is to apply the Re-H test of likelihood. Whereas the stark position, you say, is that however much the real risk is, if it's a 51-49 case, then that's the end of it.
Well, that's what we say the balance of probability
I understand
means.
that.
I know.
I mean, that might not be the law. Some might not think it's a very sensible law, but that is the law.
Well, Lord Justice thought plainly didn't in the Court of Appeal. But, my lords,
Well, I wonder if I might ask you a question which, on your analysis, is entirely theoretical. Let us suppose that a judge applies the correct test, the
Yes.
balance of probabilities, and
Yes.
says to herself or himself, well, I cannot be persuaded to the requisite level that the father or the mother inflicted these injuries. I'm satisfied on the balance of probabilities that the injuries were inflicted either by the father or by the mother or by both, but I can't be persuaded on the balance of probabilities as to who was responsible. And then asks himself the question, as between the two of them, who do I think is more likely to be the perpetrator? Is that a legitimate exercise
we say,
intellectually?
my lords, I'm delighted to engage in that, even though it is not our primary case, because this is creating considerable confusion. We would say, in short, the answer to that is a long answer, and I will, if I may, engage in it, but we will say, in short, once we establish the test of the balance, taking Lord Nichols' speech the source of this isn't helpful to you, unhelpful to comment on a likely perpetrator, alone the simple standard. But everything else within give a steer to the assessment process, but to draw back from actually identifying likelihood at a test below the simple standard. It isn't necessary. It's fraught with confusion. We said before it's a danger to shipping. And, my Lord, we say that the added danger for such an indication is what are the assessors to make of it? The point I raised before in response to my Lord's question.
Well, perhaps I could just interrupt you briefly. When you get to the stage, when the judge gets to the stage of saying, I cannot be satisfied on the balance of probabilities that father or mother was responsible for these injuries, what scope thereafter is available to the judge to give what you describe as a steer?
We would entirely follow the guidance of Lord Nichols in Re O and N, which we would look at. Adopt Lord Justice Thorpe's phrase, if you can't find it on the balance of probabilities,
Say nothing.
say nothing on the issue of perpetrator. The whole raft of things that the judge can say. And Lord Nichols gives examples of that. In reading, the court effectively took Nichols' speech which had given rise to the which had led to the confusion. We say that in the context of O&N, a similar exercise, indeed a much shorter exercise, can unify the case law so that the Lancashire case, re-B and re-O&N can all stand as part of a coherent whole. But that is...
So we're going to come briefly, shortly, are we, to O&N? We'll see what we've got to strike out from Lord Nichols' speech.
We'll come to O&N, and, my lords, we see the problem in two other cases, re-A, which is at tab 4, re-M, which is at tab 2. And may I just, before lunch, just end on the way Lord Justice Wilson approaches it in re-T.
So we're looking at re-T, are we, which is a new case.
Should I wait till after lunch for this, or should...
Well, there are a few moments to go. If you'd like to look at re-T, which is, I think, it's tab 21, is it?
Which one do you want us to look at first, though?
Why?
T, please.
Which is, it's the additional case we got this morning.
It is.
Which tab is this?
It's the additional case.
I
think.
Look at the one where it's
Yes.
first.
Well, I think perhaps it might be wiser to rise. And I think there is some concern that we really ought to know what's gone wrong with Lord Nichols before we start exploring elsewhere. So can we come back and pick that point up, and then we're on some kind of predictable path.
Thank you, Will.
We look forward to seeing you again at 2 o'clock.
Thank you, Will.
Ooh.